Hello, I'm Rob Clemente from Television Education Network, and I'm with Ed Skilton from Sladen Legal. He's with me for this week's edition of Law Bites. Ed, recently you presented a webinar on conflicts of interest and enduring powers of attorney. What's the typical scenario that you see in conflicts of interest in enduring powers of attorney?
A typical scenario tends to be someone who's perhaps ignorant of their responsibilities as distinct from someone who's dishonest about their duties to the attorney. It tends to be a scenario in which there's an alleged conflict of interest and a breach of duty. So, for example, the attorney appointed by the principal under the enduring power of attorney may think that they have authority and or instructions to do certain things like make gifts, maintain dependence of the principal, enter into certain transactions, but strictly speaking, they don't have that authority, either because it's not included in the power of attorney document itself, or it's prohibited and it's not consistent with actually what the donor of the power, who we mostly refer to as a principal, has instructed the attorney to do. Sometimes that will relate to conflict transactions where the attorney benefits him or herself. Often it will involve third parties, and sometimes that will also involve other structures, for example, superannuation. And it's in that superannuation arena that we're seeing a few more cases than what we used to see. For example, with a self-managed superannuation fund, the deed may prescribe what an attorney can or cannot do in relation to binding death benefit nomination forms. For example, is the attorney permitted to sign one of those forms on behalf of the principal, who is the member of the fund? And if they are, is it merely to renew a nomination, or can it be a brand new nomination? Now, it may be that the super fund deed permits the attorney to make a binding death benefit nomination form, but that the power of attorney document or the terms around that document do not permit an attorney to enter into that kind of transaction where they're going to benefit themselves by virtue of signing this form. So there's a need to balance what the form itself says, what the instructions are from the principal, whether they can be proven as well, and also what the superannuation fund's rules dictate about this. And note that it might be different in different jurisdictions, and it might be different between a self-managed fund as distinct from, say, an industry fund or other externally managed fund.
Do you think that an attorney could actually appoint themselves as the beneficiary under a binding death benefit nomination executed by the attorney?
I think it's not impossible, but there would often be an allegation that that's an improper use of the power because the attorney's interests conflict with their duty to the attorney not to enter into such a conflict transaction. But conflict transactions can be permitted. Often what you'd be looking for is something specific in the power of attorney document that waives that conflict, at the very least something in writing signed by the principal. And I would imagine that often when that happens, it's merely because the nomination form is lapsing, as between spouses, for example, and it's being renewed on the same terms as what the principal had signed up to before, as distinct from a change from the status quo where the principal has made a nomination to person A, and then person B under power of attorney decides to revoke that nomination and make a new one in favour of him or herself. I think that's often where we're going to see some problematic cases. And sadly, it's very difficult to prove the intentions of the principal if they're not signed and witnessed by the principal at the time of making the power.
Ed, thank you very much. Ed Skilton is a regular presenter for Television Education Network. And if you'd like to see some more of Ed's webinars, go to our website and you'll find them in recorded webinars. In the meantime, thank you very much for listening.